Good morning, we have decided to disrupt your timetable. I'm sure you'll be up to the task, but we would like to hear argument on the construction point from all sides, but certainly both sides, and then we'll see where we go from there.
Very good.
So we won't deal with the section 67 point until we've heard all the argument on the construction point. That makes sense, doesn't it?
Indeed. If I may say so. Yes. My lady, my lords, good morning. In this appeal and cross-appeal concerning the Barnardo staff pension scheme, I appear with my learned friend Miss Emily Campbell for Barnardo's, the principal employer in relation to the scheme. My learned friends Mr. Simmons and Mr. Fraser Campbell appear for the member representatives, and my learned friend Mr. Nicholas Stallworthy appears for the trustees, who are neutral as regards the issues, but are here to assist the court. The appeal, my lady, my lords, this appeal raises, as you'll have seen, a short question of construction concerning the meaning in the first sentence in the definition of the expression retail prices index in Rule 53 of the scheme of the words or any replacement adopted by the trustees without prejudicing approval. And those words you'll have seen, I'm sure, more than once, not merely in our cases, but also at page 295 of your bundle. The reference to approval is to inland revenue approval under the former regime for giving privileged tax treatment to occupational pension schemes provided for at all material times by the Income and Corporation Taxes Act 1988, Chapter 1, Part 14. And that approval would be automatic if a scheme complied with relatively restrictive requirements set out in the legislation, or, as the legislation also provided, it could be conferred by the Inland Revenue as a matter of discretion on a scheme-by-scheme basis, subject to such scheme conforming to Inland Revenue prescribed requirements. And that point that I've emphasised as a matter of discretion on a scheme-by-scheme basis is significant. Now, those prescribed requirements were set out in Inland Revenue practice notes, and in particular in, as you will have seen, IR 12, the version of which, as it stood at the time of execution of the 1988 rules, is at Authorities 1, page 311 and following. IR 12 set out the types of benefits which could be provided consistent with obtaining discretionary approval, and it set the limits on the value of such benefits which could be provided. Now, most schemes, this scheme included, went the IR 12 discretionary approval route for the additional flexibilities that provided. And IR 12 provides, in the Inland Revenue context in which the provisions of the scheme were adopted, it provides for the inclusion, as is recognised in the scheme, of a rule, Rule 32, which directs you to an Inland Revenue appendix, which you'll also have seen, setting out the limits of the benefits that could be provided. And IR 12 is also the explanation, and discretionary approval is also the explanation for repeated references in the rules to the words without prejudicing approval, including, as we will have noted, as your lordships will have noted, the ladyship will have noted, in the words in Rule 53 which fall to be construed. Now, just as this appeal is being dealt with on the basis that the answer to the question of construction on the 1988 rules will be the same in relation to subsequent editions of the rules, which use the same rules, the same words, so the wording of IR 12 did not change materially when those subsequent editions were produced. So it's not necessary to refer to subsequent editions of IR 12 in this appeal. Now, as your lordships will be aware, the system of Inland Revenue approval has now been superseded by the registered pension scheme regime, as introduced by the Finance Act 2004, which has its own system of tax allowances and charges. Inland Revenue approval has been abolished as a result. The scheme is now registered with HMRC. But in consequence of the abolition of Inland Revenue approval, it is common ground, as observed by Lord Justice Lewison at paragraph 37 of his judgment, which is at MS 127, it's observed that if the trustees were to adopt a replacement index under Rule 53, the without prejudicing approval requirement has now dropped away. It obviously continues to inform the construction exercise with which we're concerned in order to understand the meaning of the rule, but the actual practical requirement has dropped away. Now, as appears from IR12, in addition to authorising in an approved scheme the inclusion of a number of other benefits and setting limits in relation to them, IR12 authorised the inclusion of provisions for increases of pensions in payment, excuse me, and of provisions for increases of deferred pensions, and referred to limits in relation to those increases also. And you will have seen that in the first set of authority that you'd be provided with, commencing at MS 316, you will have seen that at paragraphs 7.1 and 7.2 of IR12, that's at 324, and at paragraph 13.3 in relation to deferred pensions, which I apologise is a hand-in that we put into you late, you'll see that in each of those cases, and perhaps we can pick up at 324 to start with, in each of those cases there is a reference to the permissibility of providing for pension increases, and in each of those cases there's an indication of what will be permissible and what will be acceptable as a matter of discretion. So if we go to 324 in the first instance, paragraph 7.1, if you have that, pensions already in course of payment may be further increased to offset or partly offset rises in the cost of living, and there's an asterisk there since the date of falling into payment. And 7.2, if desired, rules may provide in advance for increases in pensions to offset rises in the cost of living. And there's the asterisk. And then there is an indication as to what may be acceptable. A is 3%, we pick up B, we can see C, and then D, increases reflecting the rise in the cost of living, but not exceeding a stated maximum percentage per annum compound, if the maximum percentage is to be acceptable for funding purposes and for valuing the pension for commutation, it must be reasonable in the light of long-term trends in the cost of living. So little d of itself gives you no steer as to what the particular index might be. It just must be, if you're to adopt an index, it must be an index which is reasonable in the light of long-term trends in the cost of living. The little asterisk, which we saw in 7.1 and 7.2, we're told at the bottom of 7.3, takes us back to a footnote at 614, and that footnote is at MS 316. And that footnote tells us, in the context of another concept which I'm going to refer you to shortly, in the context of final remuneration, 614 says, increases in the cost of living may be measured by the index of retail prices published by the Department of Employment, form of words which you'll have seen is used in the scheme, or by any other suitable index agreed for the particular scheme by the Inland Revenue Superannuation Funds Office. So by any other suitable index agreed for the particular scheme by the SFO. And this feeds into the point which I made right at the beginning, that inland revenue approval is provided, or was provided, on a scheme-by-scheme basis by agreement between the revenue and the promoters of the scheme, or the amenders of the scheme, having regard to the circumstances of the scheme. And a like point derives from paragraphs 13.2 and paragraph 13.3 of IR 12, which I hope you've got a copy of, which was provided late, I apologise, at the end of last week. I don't know if you got that. You haven't got it. Well, I do apologise. Maybe hand it in.
Yes. Has it been sent electronically as well?
Yes.
My lady says it.
Well, I've got a separate document.
Ah, very good.
Headed Part
I also
13.
lack it, I regret to say.
Sorry, I do apologise. Forgive me. It was realised on Thursday that this really should have been in your bundle, and agreed by my learned friends.
This is the document headed Part 13, withdrawal from service.
Very good, my lady. Yes, and it's the deferred pensioners equivalent to the pensioners provision. And in the interest of transparency, we've given you the whole of Part 13 as we did in Authorities 1 in relation to Part 6. But and in relation to Part 7, and you'll see at 13.2 and 13.3 an equivalent reference to the cost of living and asterisked back to 614. So 13.2, if a withdrawing employee's benefits are to be preserved by providing him with a deferred benefit, and then 13.3, the maximum figure which can be provided in accordance with 13.2 above may be increased when the payment begins by a percentage not exceeding the percentage increase in the cost of living over the period of deferment, or alternatively at a fixed rate not exceeding 5%. And a cross-reference to 614. So as I say, what IR12 confirmed in relation to the inland revenue limit in relation to pension increases or deferred pension increases was that it was capable of agreement on a scheme-by-scheme basis. And as you will have seen, such inland revenue limit was not necessarily linked to the Retail Prices Index or any official replacement of that index on the discontinuance of RPI. Now, there are 4 very important points in our submission about inland revenue limits, which actually emerge from the rules themselves when you look at them. But in order to fully appreciate those points, I hope you'll bear with me if I very quickly take you to the rules which are material to the point of construction in this case, because the rules actually set up the point which I wish to make to you concerning inland revenue limits, which is a point that there is really no necessary convergence or congruence between the scale benefits that you find in the rules and the inland revenue limits. They are focused on different things. They provide for those different things in different ways. And to the extent that they use different language, that's not at all surprising. And it is our submission in this court, and obviously I wasn't there in the Court of Appeal or at first instance, and I say this with the greatest of respect, but one does get the impression that the divergence and the lack of congruence between scale benefits under a scheme on the one hand and inland revenue limits as provided for in the Inland Revenue Appendix, that lack of congruence and the absence of any necessity of congruence was not fully appreciated and may not have been fully understood in the process of seeking to as it were, seamlessly construe what appears on the one hand in the first sentence of Rule 53, and on the other hand as what appears in paragraph 10 of the Inland Revenue Appendix. But first to the rules, if I may, and we can take this swiftly. As you are aware, the rules start at MS 247. It's Appendix 7. And we see from Clause 3 at 251 that these rules, the rules which were made on the 10th of April 1991, subject to Clause 7 below, take effect from the 1st of April 1988. And Clause 7, if we just turn the page to 252, Clause 7 makes clear that it's all benefits, save for the benefits of those who've ceased to be in pensionable service prior to the 1st of April 1988, that are governed by these rules. And one then sees in subsequent editions of the rules the same formulation was adopted, which is one of the reasons why we don't need to trouble you with subsequent editions of the rules. Now, the next point, and this is a point of some interest, is the defined benefits under the rules, and they're to be found at 259. And at 259, you see Rule 7 provides for the scale pension, and the scale pension is at 7.2, the utterly conventional n/60ths of final pensionable earnings. So 1/60th of final pensionable earnings and if we wouldn't mind, as it were, notionally underlining final pensionable earnings for each complete year of pensionable service, so that feeds the numerator in the 60th fraction, with a proportionate amount for each additional complete day of pensionable service. So n/60ths of final pensionable earnings. For final pensionable earnings, we turn to 294. 294 in the definition rule, Rule 53, at the top of the page, final pensionable earnings, if you have that. Final pensionable earnings means, in respect of a member, the highest of his pensionable earnings, important, for any 12 consecutive months during the last 3 years' service up to the date of ceasing to be in service or attainment of normal retirement date of earlier. Pensionable earnings, drop down page 294. Pensionable earnings, and this is the point which I'm leading into. Pensionable earnings of a member during a period means the basic salary receivable by him in that period, excluding bonuses, overtime, and commission. So I'd ask you, please, to bear in mind the relatively limited and ungenerous, or certainly unliberal, definition of pensionable earnings for the purposes of the scale benefit which is provided under these rules. It's simply basic salary, excluding bonuses, overtime, and commission. Now, we can then go to Rule 30, which is the rule which is obviously close to home. And Rule 30 at MS 273 is the pension increase rule. And Rule 30.1.1 deals with increases to pensions in the course of payment. Rule 30.1.2 deals with increases to pensions whilst in deferment. It deals separately with increases to guaranteed minimum pensions and the benefit over and above the guaranteed minimum pension. We don't need to concern ourselves with guaranteed minimum pensions here. We're only concerned with the increases conferred on the element of the pension which exceeds GMPs. And we see from both 30.1.1 and 30.1.2 that the increase which is to be conferred in relation to the pension in excess of GMPs it's an increase at the prescribed rate in each case, the prescribed rate. So we are concerned in this rule and in this appeal, with the meaning of the expression the prescribed rate, which is supplied by 30.1.3. For the purposes of this Rule 30, the prescribed rate means an increase at the rate of the lesser of 5%, so 5% is the cap, and B, the percentage rise in the retail prices index, if any, over the year ending on the previous 31st of December. And we're then told in 30.1.5 that the increases under this rule referable to benefits, well actually, sorry, forgive me, we're told this in 30.1.1 and 30.1.2, we're told that the increases to the pension in excess of GMPs, calculated by reference to the rise in the index to the preceding 31st of December, that increase will be conferred on the following 1st of April. We're told that in the middle of 30.1.1, and we're told that in the third subparagraph under 30.1.2. It's an increase on the 1st of April, following the ascertainment of a percentage rise in the retail prices index over the year ending in the previous 31st of December. So that's the increase rule with which we're concerned. We're concerned with the prescribed rate, and the prescribed rate uses the expression retail prices index. Now, as to the meaning of retail prices index, as we know, we find that in Rule 53 and at MS 295. And we actually find that meaning supplied by the first sentence of the definition. Retail Prices Index means the general index of retail prices published by the Department of Employment or any replacement adopted by the trustees without prejudicing approval. Now, the second sentence of the definition of Retail Prices Index goes on to explain what is meant where it is said that an amount is to be increased in line with the Retail Prices Index. That's what it tells you. It's elucidating what is meant when it is said that an amount is to be increased in line with the Retail Prices Index. And it refers to a form of words in line with the Retail Prices Index, nowhere used in Rule 30, and nowhere used elsewhere in the main body of the rules at all. Now, Rule 30, as we've seen, uses the expression prescribed rate, and the prescribed rate merely refers to the Retail Prices Index, and Rule 30 then goes on to elucidate how the Retail Prices Index works. You look at the increase in that index over a period from the 1st of January to the 31st of December. That's what Rule 30 tells you. And it further then tells you that when you've ascertained the increase of the index within the four corners of Rule 30, you then confer an increase on the 1st of April. There is not only do the words increased in line with the Retail Prices Index not appear in Rule 30, not only do they not appear anywhere in the concept of the prescribed rate, but they give no added value conceptually to what appears in Rule 30. Because everything that you need to know in terms of the operation of the Retail Prices Index as regards the prescribed rate is provided by Rule 30. Rule 30, as I say, tells you the machinery, it gives you the calculation basis upon which the Retail Prices Index operates. The second sentence of Rule 30 really brings nothing to the party. And obviously the obvious point, which clearly I'm going to develop, it's a short point, which has got it, is the second sentence. Not only does it use an expression which nowhere appears and nowhere actually has a purpose in Rule 30, but it actually uses words which are different to the words in the first sentence, because nowhere in the second sentence do you actually find the expression or any replacement adopted by the trustee without prejudicing approval. But we'll come back to that. Now, what the second sentence actually does, as you will have seen, is that it foreshadows or signposts a provision which is contained in the Inland Revenue Appendix. It foreshadows or signposts the definition of in line with RPI, which is contained in paragraph 10 of the Inland Revenue Appendix. And that definition, as you will have seen, is at MS 301. And it echoes and to an extent expands upon, does a little bit more work than the second sentence of Rule 53. It does the work, the definition at MS 301, does the work which is done in the body of Rule 30 for the purposes of applying the Retail Prices Index in Rule 30. When you get to the definition of in line with RPI in paragraph 10 of the appendix, as I say, it echoes, to an extent mirrors, what you see in the second sentence of Rule 53, and then it does a little bit more. It does a little bit more, but it does that little bit more for the purposes of the Inland Revenue Appendix. So page 301, in line with RPI over a period means in proportion to increases between figures in the General Index of Prices Index published by the Department of Employment or a replacement of that index not prejudicing approval, immediately prior to the dates when the period began and ended, with appropriate restatement of the later figure if the index has been replaced or rebased during that period. So the extra work that's being done is in the middle It's the jam in the sandwich of the definition of in line with RPI. The extra work is that it's referring you to a period, nothing particularly insightful about this aspect of the definition, but it's referring you to the period in respect of which you are actually applying the index. It is, for the purposes of the definition of in line with RPI, doing the work which Rule 30 does itself in connection with the definition of the prescribed rate. Now, as you will have seen, that expression in line with RPI is used in the Inland Revenue Appendix, and it's used repeatedly in the Inland Revenue Appendix. It is used in 22B at MS 297, the revenue limits for a member's pension, two starts. The revenue limits for a member's pension are, on retirement at or before NRD, 1/60th of final remuneration, a point I'm going to come back to with you. On retirement after normal retirement date, the greatest of the amount in one above, B, the amount which could have been provided at NRD under one above, increased in line with RPI. And then at 2.3, you see the same concept being used again. On leaving pensionable service before NRD, you get an amount calculated as in one above, 1/60th of final remuneration for each year of service, increased in line with RPI. And then at 3.3, at 298, you see it again. On leaving pensionable service before NRD, an amount calculated as in one above, including increases in line with RPI. And then at 6, closer to home, at a point which I'm going to return to as regards what exactly the Inland Revenue Appendix does say and doesn't say. 6, pension increases. The maximum pension may be increased whilst in payment in line with RPI. 7, late retirement, final line. Penultimate line and final line, during the period of postponement between normal retirement date and the date of retirement, increased in line with RPI. And then finally, in the definition of final remuneration, which is to be found at MS 300, at 10.1b, your remuneration may be increased for each year. So the remuneration the maximum remuneration which you're entitled to receive under the definition of final remuneration may be increased each year for revenue limits purposes in line with RPI, 10.1b. And then in capital B, in the definition of final remuneration, total emoluments increased in line with RPI from the last day of that year up to the exit date. And the exit date appears at the top of the page when you retire from service. So the point which I'm drawing attention to is that the second sentence of Rule 53 has really no function at all in relation to what you find in the main body of the rules. It's inoperative in relation to Rule 30. It doesn't actually supply anything of assistance in relation to Rule 30. It is a signpost or a foreshadowing of a slightly more fulsome, comparable form of words in line with RPI to be found in in paragraph 10 of the appendix, which expression is repeatedly used in the Inland Revenue Appendix and only in the Inland Revenue Appendix. And the basic proposition, the introductory proposition, as I said earlier colloquially, is that the second sentence of the Retail Prices Index definition really doesn't bring anything to the party. as regards the interpretation of the prescribed rate. True it is, it uses the word replaced, but we know that the word replaced appears in the first sentence, so one would suggest it doesn't really assist in relation to that. True it is, it uses the word rebased, but frankly, it doesn't bring anything to the party in relation to that either, because if the second sentence had not been there, it would be perfectly obvious how you would deal with rebasing in the operation of the prescribed rate under Rule 30. And imagine two situations. Imagine a situation where the retail prices index is 300 at a given point in time, and that it's 300 on the 31st of December, and then let's say it's 300 on the 1st of January, and it becomes 330 on the 31st of December, and on the 31st of December it's rebased to 100. The index has still gone up by 10% over the year. And similarly, if the retail prices index had stood at 300 on the 1st of January, and at a time, let's say it had got to 315 on the 30th of June, and as of the 1st of July, it was rebased to 100. It's a matter of simple arithmetic to work out what the effect of that is when you're trying to work out what the increase in RPI is when, at the 31st of December, the index is no longer 100, but it's 110.
Ms. Green, that's all very well, but the argument surely is look at the body that does the rebasing.
Oh, my lord, of course one sees that, but that we say is neither here nor there. It's common ground in this case that for the purposes of the first sentence, the trustees are the active party. The trustees are the party that have to do the adopting. That's paragraph 13 of the member's case. There has to be a positive adoption. There's absolutely no reason why, when replaced and rebased are used in the same sentence in the definition of retail prices index, that they should be referring to the same actor. It's not necessary at all, particularly when your lordship has got the common ground between us, that when you're looking at the first sentence of the definition of retail prices index, the actor is the trustee when it comes to adopting. It's the actor, this is our submission, it's the trustee's act of adoption which affects the replacement. So that there is no reason why, in our submission, why looking at the second sentence in conjunction with the first sentence, it should be regarded as a sentence which determines the meaning of the words in the first sentence. But if you should start with the first sentence, because the first sentence is the sentence which is the sentence of evident relevance to the definition of the prescribed rate in Rule 30. And if you are minded, on looking at that sentence, to recognise that the force of argument favours the proposition that there is a replacement adopted by the trustees without there having to be a discontinuance of RPI in the meantime, then our submission to your lordship is that if you're minded to take that view on the force of argument by reference to the first sentence, there is absolutely no reason why that the use of the word replaced in the second sentence should cause you to repent. No reason at all. You simply recognise that in the second sentence, that word can perfectly sensibly take its meaning from what's been said in the first sentence. But there's a second answer to your lordship, and the second answer requires us to look a little bit more at the inland revenue limits, because obviously the point that you just made to me is a point which equally, and perhaps more forcefully, can be made in relation to the definition of in line with RPI to be found in paragraph 10 of the appendix. Because the Chancellor said, in relation to the definition of in line with RPI to be found in the appendix, that is at page 301, that he was inclined to take the view that the reference there to, or a replacement of that index not prejudicing approval, was a reference to an official replacement. And obviously that would in its turn produce a congruence with the final words in line with RPI, which are to be found in the definition in paragraph 10 of the appendix. Now, that may or may not be right, and I'll come back to you on as to whether it is or it isn't. For our purposes, to be perfectly honest, it doesn't actually matter at the end of the day whether it is or it isn't, because in our submission, the second sentence of Rule 53 is, as I say, merely a signpost to what you see in the Inland Revenue Appendix, and you can construe what there is in the Inland Revenue Appendix and the particular words which are found there as having a particular meaning without infecting the meaning in the first sentence of the definition of Retail Prices Index, which is all that you need in order to understand the prescribed rate. Because if you're with me, obviously if you're not with me, then clearly it's an uphill struggle, but if you're with me on the point, which I will continue to attempt to satisfy you on, that the second sentence of Rule 53 really has got nothing to contribute in relation to the prescribed rate, then what we're really discussing here is not the second sentence of Rule 53. We're discussing the interaction between the first sentence of Rule 53 and paragraph 10 of the Inland Revenue Appendix, the paragraph which in using the definition in line with RPI reproduces the wording which has been foreshadowed in the second sentence of Rule 53. And it may be, as I say, it may be that in using the wording or a replacement of that index, not prejudicing approval, rather than wording or a replacement prices index adopted by the trustees without prejudicing approval, it may be that that different wording does signify a different meaning. Maybe. But I would emphasize that it is different wording, and one perhaps shouldn't be overly led astray by the common use of the word replacement. It is different wording, and it's doubly different. Let me stress this. These are such short and simple points. I'm almost embarrassed to be articulating them, but may I? The wording in Rule 53, first sentence is, or any replacement prices index, because we know that's the subject of the definition, or any replacement prices index adopted by the trustees without prejudicing approval. Adopted by the trustees without prejudicing approval. So it's the act of adoption by the trustees, which we say affects the replacement, which has to be tested to see whether it prejudices approval. An adoption without prejudicing approval. Here we have, or a replacement of that index, this was the Chancellor's point, where he said, I rather think that in this particular case they are referring to a discontinuance of RPI and a republication, because it says a replacement of that index. But it says a replacement of that index, that's the first point, no reference to the trustees being an active party. And it doesn't say without prejudicing approval, it says not prejudicing approval. So its focus is on the replacement, not prejudicing approval. Whereas in the first sentence of Rule 53, the focus is on the adoption without prejudicing approval. Now,
What's the difference?
Well, but we say that there is a significant difference, because we say that the first sentence is looking at a replacement from the spectrum of replacements which are capable of being adopted by trustees, so long as they are prices indexes, consumer prices indexes.
But what is the thing that mustn't prejudice the approval?
The adoption. We say in relation to the first sentence of Rule 53, it is the adoption by the trustees of the particular index which mustn't prejudice approval.
Yes, but it is the terms of the index that will either gain or not gain the revenue's approval.
Well,
It's not the method by which the trustees have adopted it.
No.
What they will look to is what is the consequence of the use of this index.
Absolutely. But the point that I'm making is that it's a much more compressed concept with which you're dealing in the Inland Revenue Appendix. The concept is simply the plain vanilla concept of a replacement not prejudicing approval. And and for reasons which I'm going to come on to shortly, it's not necessarily right, but if the Chancellor is right, and the members are inclined to go with the Chancellor on this, at paragraph 27 in their case, if the Chancellor is right, that, well, look, when you look at in line with RPI, it's more compressed wording, and that a replacement of that index is taking you remorselessly to the notion that this is an official replacement. Then the point that I'm trying to make is that all we've got is the concept of replacement here, and the test of whether that replacement prejudices approval. Whereas in the first sentence of Rule 53, we have a more complex concept. Can't overstate its complexity, because it's certainly not the most complex proposition that you'll have heard sitting in this court or in any other circumstance. But it's a more complex proposition. It is a replacement adopted by the trustees without prejudicing.
But wouldn't the Inland Revenue, when saying to itself, well, should this secure our approval, wouldn't it be looking at the replacement index?
Yes.
Rather than the adoption of it as such?
That's the point.
Yes. But I'm simply saying that the emphasis of the provision is different. It is a provision in the case of the Inland Revenue Appendix, which is looking at a process which doesn't involve the trustees at all. If you confine your eye to the language of in line with RPI alone. Okay? But the reason we got into this was because I was saying that, okay, let us assume that the Chancellor is right. Let us assume that the members are right in paragraph 27 of their case. Let us assume that in the case of the definition in the Inland Revenue Appendix, the replacement which is being referred to is an official replacement. Let us assume that. In that case, then, looking at the final line of that definition, the same actor is replacing and rebasing. Fine. That gets rid of that particular issue in relation to the Inland Revenue Appendix. But the proposition remains, our proposition remains, that it's not the Inland Revenue Appendix with which you are concerned. And I'm going to make my 4 points in a second, hopefully, to further reassure you that that is the case. Obviously, the starting point is the opening simple submission that the second sentence of Rule 53 brings nothing to the party. Nothing to the party at all.
But is it capable of being a different party? In other words, can you think of any factual scenario under which the application of the prescribed rate in accordance with Rules 30 and 53 would be other than a replacement in line with RPI?
Well, yes. If the members are right, if the members are right, if the Chancellor is right, then yes, there could easily be a factual scenario. Because if the members are right, the only index that could satisfy in line with RPI would be a replacement of RPI on its discontinuance.
But it would have to be one not prejudicing approval.
Oh yes, indeed.
And replacement in that general terms would, in the in line with RPI definition, would be following a discontinuance.
No, that's right. So that's the members. That's the members.
Yes, but on the members' case, that doesn't produce a different party. In other words, it doesn't produce a situation where prescribed rate operation is not in line with RPI.
Oh no, that's
But
right.
on your analysis, does it?
On my analysis, you could have a different index, yes, because on my analysis, and my 4 points on inland revenue limits are going to hopefully put your mind at rest in relation to this point. On my analysis, if the members are right, and if the Chancellor is right in relation to in line with RPI, you may have a different index operating for the purposes of the prescribed rate, because the index which can operate for the purposes of the prescribed rate merely needs to be any replacement adopted by the trustees without prejudicing approval. And that replacement need not be a replacement which is
So that would then not be in line with RPI.
Correct.
So on your construction, increases under Rules 30 and 53 would not be increases in accordance with the appendix.
No, that's not right, because for the reason which I'm about to explain to you. They would be increases which did not, my Lord, they would be increases which do not fall within the definition of in line with RPI.
Yes.
But they would be increases which would clearly satisfy the requirements of the rules on our construction, and they would not give rise to a concern as to the mismatch in terms of the increases because of the way in which inland revenue limits actually operate.
Well, if the trustees had chosen a 4%, an index which yielded 4% in a particular year, but it wasn't in line with RPI,
yes,
because it wasn't a successor index
yes, indeed,
to the retail price index, how would the increase under Rules 30 and 53 comply with the limitation in paragraph 6 of the appendix?
Well, and that's what I was about to explain to you. I'm about to do that. So I better do that now. The point is this. Inland revenue limits do not involve a ticking off, a cross-check of each individual benefit provided under rules against what's contained in the Inland Revenue Appendix. What inland revenue limits involve, and I'm going to show you this from the rules, is taking the combined, the aggregate value of the emergent benefit under the rules and comparing it with the aggregate maximum benefit which can be provided in relation to that particular member having regard to his circumstances. And when you look at, well, let's start with paragraph 6 of the Inland Revenue Appendix. Though I'm going to have to take this slightly more slowly. When you look at paragraph 6, to begin to answer my Lord Briggs's point, what paragraph 6 actually says, and this is terribly important, is that, we're at MS 299, the maximum pension, not the pension, the maximum pension, i.e. the pension consistent with all the other limits which are provided for, the maximum pension may be increased whilst in payment in line with RPI. And the maximum pension, as I say, is what the inland revenue limits are interested in. And the maximum pension is, if you go back to page 297, paragraph 2, the revenue limits for a member's pension, 1, on retirement at or before normal retirement date, is 1/60th of final remuneration, not final pensionable earnings, which is why I laboured final pensionable earnings earlier, for each year of service with the employers not exceeding 40. Final remuneration is defined at page 300, MS 300. And you can evidently read into this yourselves, but the basic point is that final remuneration includes total emoluments, whether fluctuating emoluments under one heading or all emoluments under another heading. And emoluments, when you look at C, shall be deemed to include the value assessed for income tax of benefits in kind. And not merely that, not only does final remuneration for inland revenue limit purposes permit a notion of remuneration which includes not merely basic salary and bonuses and commission, but benefits in kind. But what is more, as we skipped over when I was showing you the examples of increased in line with RPI, that remuneration, inclusive of bonuses, commissions, and benefits in kind, could itself be index linked. So N/60ths times final remuneration for the purposes of inland revenue limits could be N/60ths times remuneration calculated by reference to basic salary, bonuses, commission, benefits in kind, index linked by reference to the year in which the salary actually arose. And only if you exceeded that particular limit, which obviously was pretty difficult to do, would you exceed the limit for the maximum pension. And then you get to paragraph 6, and paragraph 6 says, and furthermore, the limit for the pension, the emergent pension, can itself, the increases to be provided on the emergent pension, can themselves be indexed in line with RPI. So,
am I wrong to read the appendix as dealing in paragraph 2 with the ceiling for a non-indexed pension up to a stated maximum of 1/60th of final remuneration, and in paragraph 6 as providing for a limited element of indexation in line with RPI? Rather than saying it's one global figure in every year and providing the amount by which you index under your own index is more than an in line with RPI increase, that's all right, providing your pre-indexation maximum is sufficiently far below the ceiling set by Rule 2.
My Lord, no, it goes further than that. It goes further than that. It's saying that we're going to look at Rule 32, which is the intro to this. It goes further than that. It is that the inland revenue limit on the benefit which can be provided in relation to any individual is the maximum pension, excuse me, which is itself, as we've said, based on final remuneration, which is itself capable of being an indexed concept, indexed in line with RPI. And if the emergent benefit under the rules, however that benefit was made up, on the basis of a generous notion of final pensionable earnings or an ungenerous notion, on the basis of a generous index, because to take your Lordship's example of earlier, at this time, and certainly in earlier times, it was common to find fixed rate pension increase rules. The question for the inland revenue limits, the question for the purposes of the inland revenue appendix would be whether the emergent benefit, let us say a benefit based on n/60ths of final pensionable earnings plus 5% per year pension increases, overstepped the inland revenue maximum, which was n/60ths times final remuneration, increased by in line with RPI. That's the question. And the lead-in to that point is Rule 32, which is to be found at MS 274. It's 274 to 275, and the key point is the final sentence of 274 to 275. If a combination of payments, if the aggregation of the payments, if the payments in combination would prejudice tax approval or cause the trustees to be in breach of an undertaking, the trustees will reduce all or any of them in such manner as they think fit, but to the extent only as being necessary to prevent tax approval being prejudiced. So we're looking at a combination. There's two further points on the Inland Revenue Appendix. The first point...
Just before you go there,
yes.
But the question whether the limits in the appendix are exceeded, i.e. whether there are two separate limits, a maximum limit and an indexation or increases limit, or one overall limit where you mustn't exceed the aggregate, surely is a matter of construction of the appendix rather than Rule 32.
Indeed. Well, yeah, indeed, and I'm just... No, that's absolutely right, although Rule 32, as it were, introduces the appendix,
yes,
and brings it into play specifically. There's also the general introduction in the deed, which says the rules in the appendix apply to the scheme, as you'd expect. The next point to bear in mind in relation to the Inland Revenue Appendix, and again, the lack of congruence between what's in the appendix and what's in these specific rules, comes from paragraph 1 of the appendix. And that is at MS 297. These limits, or limits in inland revenue appendices, are not about a simple cross-check of the scale benefits to be found in a single set of rules. They're about a cross-check against the benefits provided by all schemes provided by a particular employer. So the point that I'm simply making here is that you should not be dismayed if the inland revenue limits are targeted on one potentially greater thing, which is, in my submission, they are, which is something really quite different to what the rules are targeted on. Now, it so happens in this case that Barnardo's only had one scheme. There is no other scheme to bring into account here. Okay? I immediately accept that. But this paragraph highlights the nature of the inland revenue limits and the nature of the appendix. It is an aggregate value cross-check against the aggregate emergent benefit from this scheme and others. And then there's one final point I'd like to draw to your attention. And this goes to the construction of in line with RPI. And I think, and I wasn't there in the Court of Appeal or before Mr. Justice Warren, and so I'll stand corrected, but I'm not sure that this did receive attention. We've debated the extent to which the expression in line with RPI, as used in the appendix, may have a more limited signification than the first sentence on our construction of Rule 53, and whether that more limited signification derives from the use of the expression or a replacement of that index not prejudicing approval. But there is an important set of introductory words at the beginning of paragraph 10. What the beginning of paragraph 10 says at MS 299 is, this appendix is a summary of the revenue limits, and then the key. Benefits may exceed the limits set out above, with the prior consent of the Board of Inland Revenue. In other words, I accept it says set out above, but obviously it may exceed limits, including the references to increases in line with RPI, which are repeatedly used above. It's apparent from these introductory words that the definition of in line with RPI, as it appears in paragraph 10, is not set in stone. And that even if the natural construction of replacement of that index is thought to be an official replacement, even if that's so, bearing in mind what you know about IR12 and the fact that other indices, other cost of living indices, were potentially capable of adoption on a scheme-by-scheme basis. What this sentence shows you, what it tells you, is that in fact that concept of in line with RPI is not a fixed concept, even if in line with RPI as set out on MS 301 is to be conceived as being as involving a concept of a replacement, an official replacement. Nevertheless, there is a wider possibility of replacement acknowledged in the second sentence of the introductory words of the interpretation paragraph. And that replacement could obviously be a replacement which appeals to the parties, the relevant party for the purposes of this argument being the trustees, wishing to adopt a replacement index which the trustees consider to be more appropriate for the purposes of protecting the members from the effects of inflation than RPI that remains published. So what I'm saying to your lordships is that where this submission goes is that even if you are inclined to read the words in line with RPI as contemplating replacements which are official replacements, the fact is that there was always a flexibility within the definition concept itself, introduced by the second sentence of the interpretation paragraph, which was a wide enough flexibility to embrace replacements which were other than official replacements. Which brings me back to the point which I made a little while ago, which it feeds into the submission that the second sentence of Rule 53, and really we say paragraph 10 of the appendix, really doesn't give you the answer here, because whether you're inclined to take the line that the members do and that the Chancellor did, of saying that replacement of that index means in the definition of in line with RPI, as we see it on the page, an official replacement, or whether we're rather inclined to do, on the basis of IR12 and on the basis of that IR12 feeding into the second sentence of the introductory words of the interpretation paragraph. So whether you take the members' view or whether you take the view that we're rather inclined to, that IR12 plus the second sentence gives you the requisite power and the requisite signal, such that we'd say, well, the Inland Revenue Appendix is constructed around the possibility of a replacement adopted by the trustees or some other replacement. Whichever one of those two approaches you take, it doesn't actually meet the fundamental point in this case, which is that the second sentence of Rule 53 is a tail which frankly is not even attached to the dog, let alone wagging it. And that the second sentence of Rule 53 is about what you see in the Inland Revenue Appendix. And what you see in the Inland Revenue Appendix is not what Rule 30 is about. It's not the same words as in Rule 30. It does have the potentiality of flexibility in it, but even if it doesn't, with the greatest of respect, so what? It's got a different purpose. And if it is a tail attached to the dog, it shouldn't be wagging this particular dog. What should be wagging this particular dog is the dog. And so far as regards that, that takes us to what is the true construction of the first sentence. And on that, frankly, we say that, embarrassingly simple point, but we say that Barnardo's is right, the members, Court of Appeal, majority of the Court of Appeal, with the greatest respect, are wrong. We say it's very, very simple. Our construction is that you look at the first sentence and you see two limbs, first limb and a second limb. The first limb is the General Index of Retail Prices published by the Department of Employment, and then you've got the word or, and then the second limb says any alternative adopted by the trustees without prejudicing approval, and we say that that's a single composite concept. And it doesn't in any way invite the proposition that the replacement adopted by the trustees has to be a replacement index published by the Department of Employment on a discontinuance by it of the RPI. We say the first limb identifies the default index, the General Index of Retail Prices published by the Department of Employment. The reference to the Department of Employment is the means of identifying that index. It's again, it's a single composite. It's stated in a single breath. And then the second limb itself is freestanding. So far as we're concerned, the reference to the Department of Employment has done its work when you get to the end of the first limb. And the second limb confers, on our construction, a substantive discretion on the trustees to adopt a replacement. An index owes its status as a replacement to the act of adoption by the trustees.
So it could be any old replacement, anything the trustees fancied.
Yes.
Subject to revenue approval.
Which, of course, no longer...
And subject, obviously, to the fiduciary duty to choose an index which best meets the objective of preserving the value of pensions and deferred pensions against the effects of inflation.
But standing in the shoes of the reasonable reader in 1991, or whenever these rules are being drafted, who was familiar with revenue, one has to assume a certain familiarity with revenue rules, guidance and practice. Why should he think the revenue would approve an index that didn't produce increases in line with RPI?
Because IR12, paragraph 614, asterisk, footnote,
is very loosely worded.
But I mean, worded in a way which.
But the appendix is meant to set out everyone's understanding of what the revenue's limits were. Subject to the let-out at the beginning of Appendix 10, that other indices, we would say, falling within the second sentence of paragraph 10 of the appendix, could be adopted. Mm-hmm. So, but, my lady, you've got my point, obviously, that any old index is kind of, as it were, junks my submission, as it were.
It wasn't meant to junk your
no,
submission
I know.
at all. I've been listening to it very carefully.
No, of course I know that.
Your point is IR12 allows, it appears to allow trustees to adopt indices which are not government-sponsored indices. And there is case law where their schemes use wording which seems to support such a power on the part of the trustees. We haven't looked at them, but they're in the written cases.
Well, I'm not actually relying on any particular cases.
No, because they're differently worded, but they do show that people's understanding of IR12 was that you could adopt non-official indices.
Oh,
yeah.
Look, it's quite clear that IR12 was leaving open the index that you could adopt.
Yeah. And the big question is why use the word replace?
Well, to which our response is, why not? Because it's a perfectly appropriate word to describe the process, the single compound process of any replacement adopted by the trustees. That the act of adoption, as I said a moment ago, is that which affects the replacement. Replacement of what? Replacement of the retail prices index, which was the default index prior to the act of adoption causing the replacement to occur. That's the interpretation. And perhaps I should say that obviously it's theoretically possible that alternative indices would have been promoted by trustees, which didn't have an official origin. But it's quite the only point which we are contending against is the notion that the only index that could replace the default index under Rule 53 is an index which is published on a discontinuance of the default index. So we have no difficulty to pick up with something which I had personal experience of in the BT case. As you will have seen from the Chancellor's narrative of the points which was common ground before the Court of Appeal that Mr. Justice Warren had slightly overlooked. There were a series of official indices in existence in 1991, not merely the retail prices index. And one of those indices, which was about to become the government's frontline measure of inflation for macroeconomic purposes, was RPIX. RPIX dated from the 1970s, and in 1992, between 1992 and 2003, when CPI took over, it was the government's frontline measure of inflation. And as you'll have seen, as you may well know, RPIX is RPI with the exclusion of mortgage interest payments. And one of the points which was in debate between the experts in the BT case, for the trustees, was, well, if you've got pensioners, how relevant is it to have an index for pensioners which is responsive to mortgage interest payments? Because most pensioners own their own houses. So it's that sort of point. One can't, obviously, there's no expert evidence in this case, but one can't. There is a context to all of this. There were other official indices. The number of official indices have increased in number since 1991. And the point which we are debating is whether the draftsman in 1991 would, in using the wording that he or she used, could have been fixated on the only candidate index for adoption being an index which arose out of the discontinuance of RPI. So, as I say, it's a matter of recognizing in a sensible way that we're not talking about a casually adopted index, either as a matter of fact or as a matter of law, as a matter of fiduciary duty. But we are debating the question of whether, when you are looking at words which conceive of a replacement adopted by the trustees, you really can imagine that those words were adopted on the basis that the only event where the trustees would actually have a role, an adoptive role, would be where the very index, which has been referred to in the first limb, has ceased to exist. Because, to take another point which we make in submission to you, which is in connection with what we say is the natural meaning of the words. The problem with the majority of the Court of Appeal's interpretation, the members' interpretation, is that it denudes the concept of the trustees adopting a replacement index of meaning. Because if you take I was going to say the ordinary case, members will no doubt say I'm speculating. If you take what is certainly one pretty credible candidate case, which is where RPI is discontinued and another index, a better index in the eyes of the Department of the Employment or whoever occupies the official seat, is published, what on earth is the role of the trustee's discretion as to whether to adopt? As I say, I repeat, it is common ground between the parties that the use of the word adopt confers an active role on the trustees. The trustees are the active party in effecting the substitution under the first line of Rule 53. Now, the members say, yes, but imagine a case where there's more than one official index published in substitution of that single thing, RPI. Well, we say that in 1991, that's rather a relatively speculative proposition of itself. You've got a single thing, RPI, and the notion that it's going to be replaced with two or more things, and that the draftsman was drafting for that eventuality, is a somewhat strained one. But we say strained or not, and we do say it's strained, but strained or not, it still doesn't answer our point. Because our point is, imagine the case, whether you regard it as the more likely case or not, and our submission is it is the more likely case, imagine the case where RPI is discontinued and only one index is published in its place. There's no role at all for the word adopted. Whereas on our construction, the word adopted functions in every case. We agree. We embrace the proposition that the second limb of the first sentence of Rule 53 is conferring a substantive discretion on the trustees. But it's conferring a substantive discretion in all cases. You can't have it both ways, as the members are seeking to have it. Because the one thing that the first sentence of Rule 53 is not doing in our respective submission is conferring a veto power on the trustees in a case where the Department of Employment discontinues RPI, decides there's a better index, publishes that index, and then the trustees, because it's common ground that they've got a discretion, they're the acting party, say, well, we're not going to adopt that index, there won't be any prescribed rate, there won't be any pension increases at all. That's not what the first sentence of Rule 53 is about. That's not what the definition of prescribed rate in Rule 30.1.3 is about. Those things are about, it's common ground, this. It's noted as common ground by the Chancellor in the Court of Appeal. What the first sentence of Rule 53 is about the trustees having power to adopt the most appropriate index in the circumstances. It's not about them having a veto power. And the idea, as I say, that in a case which can't be ignored, that a case where RPI has ceased to be published, a new index has been published, the idea that the use of the word adopted is there somehow to enable the trustees to stymie what officialdom have done, is surely foreign to the power. So we say those two things essentially, that the concept of replacement is certainly not OTOs in our construction. Adoption affects the replacement, and it is a perfectly natural and sensible reading of the concept of replacement to go with Barnardo's construction. And we say further that if you don't go with the Barnardo's construction, then you do reach a difficulty. You face a serious difficulty. In a case, let's be absurdly open-minded and say one only of possible case, where RPI is discontinued and it is replaced by a single index, because there the word adopted simply doesn't function. And we do take the related point, though I will freely admit that it does run into a certain tension in relation to the use of the expression in line with RPI in Appendix 10. We do take a related point. Maybe it's only got force as an observation rather than a persuasive submission because of in line with RPI in the appendix. But if the first sentence of Rule 53 is simply about a case where RPI has been discontinued and it has been replaced by one index or two or more indices, but let's start with one index because the members can't say that that's not a likely scenario. What exactly is the significance of the words without prejudicing approval? You know, we're in a world, in this hypothetical world, where the Department of Employment has been publishing RPI. RPI has been treated as a perfectly appropriate index by the Inland Revenue for the purposes of thousands and thousands of pension schemes and the conferment of discretionary approval. The Department of Employment undertakes research, and it determines that there is a better index available for the purposes of charting price inflation.
Are you assuming that the designation of another index as a replacement of the RPI by the relevant government department would be conclusive? I mean, let us suppose that they discontinued the RPI and declared that they were going to replace it by an index compiled on a very different basis. That necessarily have to be regarded as a replacement if it worked entirely differently, because the government department had said, this is what we regard as a replacement.
Well, my Lord, if I may say, that's a very interesting question, and because what I had considered putting to your lordships that, if I may put the point back to you, the same point perhaps to develop it, is there may be on the members' construction a question of construction as to what the word replacement means, because they do because if you are promoting the notion that the only thing that can satisfy the second limb is a replacement of RPI, then you invite a question, an official replacement of RPI, you invite a question as to whether that thing is properly to be described as a replacement, and you find yourself in court with Mr. Paul Johnson giving evidence and all manner of other people giving evidence as to the methodological characteristics of the index. But I would suggest, if I may, to you that perhaps all of this is hypothetical, obviously. It's perhaps less than likely that was a concern motivating the adoption of the words at the particular time for this reason. And it's another point which we've made in our case, although we're lambasted for it by the members. The fact of the matter is, I mean, if you just transport yourself back to 1991, The retail prices index was dominant in 1991. It was used for the purposes of countless commercial contracts and arrangements, index-linked gilts, pension schemes. It had an enormous use. The notion that in 1991, in drafting this particular rule, the draftsman, all the parties in signing up to this deed, were intending to provide for a circumstance where officialdom discontinued RPI and replaced it, not simply replaced it, but on the members' submission in order to give content to the trustee's discretion, replaced it with two or more indices. That notion is inherently implausible as informing the basis of the drafting of the provision. You know, one of the reasons, as you'll know, why we've still got RPI today, 27 years on from 1991, is that getting rid of it is practically impossible because it has been adopted in so many commercial arrangements. It's there in so many contracts. It's there in index-linked gilt arrangements going through to 2030 and beyond, which is why the publication of the RPI is now required by statute, as you probably saw from some of the case law. It's an actual positive requirement of the statute. It's the only index which statute requires should be published. That dates from 2007, not 1991. The notion, given the widespread and embedded use of RPI, that in 1991 they were attempting to draft for its discontinuance and official replacement with frankly, the chaos that would have caused. Particularly.
You don't have to assume, do you, that the draftsman thought that this was particularly probable or had any view one way or the other about how likely it was. Whenever in a contract or a legal instrument include a provision for variation by reference to some external source of information, it's an absolutely standard drafting problem that you have to cater for the possibility that the chosen external source may, for some supervening reason, turn out to be no good. It disappears, it starts to be constructed on a completely different basis, which is irrelevant to its objective, and so on. So you don't have to assume that the parties had worked out a kind of game plan for government indices. It's just a bog standard drafting technique.
Well, my lord, it's a bog standard drafting technique for dealing with anticipated variations. But I would suggest that your lordship can take judicial notice of the proposition that out there there will be an infinity of commercial contracts which do not include that bog standard drafting technique of a provision which says if the RPI should be discontinued, there will be another index. And
a lot of badly drafted contracts around.
Well, okay, well, I suggest to your lordship that one reason why the proposition that discontinuance of RPI would not have been at the forefront of the minds of parties entering into this commercial arrangement was that discontinuance of RPI would have had such widespread repercussions that the notion that you were drafting for it and for it alone is inherently less plausible than the notion which we put before you, that you're drafting for the possibility of other adopted replacements, and that the proposition that RPI might be replaced by two or more indices is an even more difficult to stomach proposition, because that raises difficult issues for all those many contracts and other arrangements out there as to which of those indices is actually going to be the one that governs in the future.
I mean, the draftsman of a pension scheme has got to draft for eventualities that may occur for a period corresponding to the maximum life and maximum period of an employee's career, so that he is. This is a particularly long-term kind of instrument, and one, therefore, where speculation about what may happen is more than usually useless.
Well, Your Lordship has my submission.
Mr. Green, you've been talking a bit about what replacement means. I mean, if contrary to all your submissions, there's got to be an official replacement for the purposes of this definition in the rules, it just crossed my mind that there had been loosely a replacement because, correct me if I'm wrong, the RPI was a national statistic, quote unquote. It is no longer a national statistic, quote unquote, and the CPI, or possibly CPIH, is now a national statistic, quote unquote. And so I think this was touched on by Mr. Justice Warren, and he dismissed the point. And it was never taken by Barnardo's in the Court of Appeal, and you're not taking it now. So it must be a bad point.
It is. Yes, we think it is with the greatest of respect, but in any event, we haven't taken it below, and I certainly can't take it now. No, I think we accept that so long as RPI is published, that the fact that it's fallen out of fashion in many quarters, not in all quarters, and the fact that it no longer enjoys national statistic status does not enable us to say that it has been replaced within the contemplation of this rule.
Thank you.
But thank you for raising it.
Mr. Green, could I just hark back once more on the appendix?
Of course.
Just as a matter of evidence, is the appendix as a sort of standard document which you simply adopt lock, stock and barrel provided by the revenue, such that all schemes that have a revenue limits appendix will be word for word the same? Or is it a document prepared by the team, let's put it that way, drafting these rules as setting out their understanding of what the revenue position was or was likely to be?
It's I mean, I can't tell you exactly the provenance of this one, but generally it's the latter. I mean, I think that there was a period, I'll stand corrected on this, where the Inland Revenue did publish a version of an Inland Revenue appendix. But I think that you've got just different in-house forms of Inland Revenue appendices, some of them in the same font as the remainder of the rules, some of them in much smaller font.
So you're saying we don't know, or it's probably in-house drafted?
Well, I don't know, but I would imagine, frankly, what it's worth, it's in-house drafted. I mean, quite a few people came to put them in smaller font because sometimes members got the impression that their benefits were the ones in the Inland Revenue Appendix, which, of course, it's my submission that we shouldn't fall into that particular trap here.
And the reason I'm asking is because of the tension on which you rely between what IR12 says and what the appendix says about in line with RPI.
Yes. Yeah, I think that we can, well, and I'll stand corrected. I think we can proceed on the footing that this was produced by the educated persons who produced the rest of the rules, but it was as it were their form of words, more or less. You'll find the same sentiments, to a greater or lesser extent, and underlined to a greater rather than lesser extent in any other Inland Revenue appendix. This is the basic shape of the things. No, so we do say that it is a simple matter of construction, and we do say that frankly, if you look at the case that's made against us in relation to this, there is really no satisfactory answer to the natural simple form of words, the substantive role for the word adopted, and, as we say, the fact that it's very strange to contemplate that if officialdom have produced a better index than the RPI, that would be contemplated by those drafting this provision as giving rise to a question as to whether that better index prejudiced approval. Particularly strange to think that the trustees would be the policemen of that the idea that this provision in the first sentence of Rule 53 is drafted as it is in order to cater for the possibility of the Department of Employment overstepping the mark with the Inland Revenue, and the trustees being the arbiter, being the policeman of whether they have or they haven't, by ensuring by the process of adoption that revenue approval has not been lost. That's surely not what this provision is about. This provision is about the trustees self-regulating, exercising their discretion, but subject to the general warning that you don't exercise your discretion in a way which prejudices approval. And as I say, when you look at the case against us, the case against us is with respect, stridently expressed, but extremely thin in our respectful submission. It says that we don't give a substantive role to the word replacement. It says that the word replacement is OTAs. But it's not. We've already answered that. The process of adoption affects the replacement. It's a perfectly natural concept. It's said against us that, you'll have seen paragraphs 15 to 16 of the member's case. It's said against us that the draftsman could have used different words. And if the draftsman had used different words, the result might have been different. Well, the answer to that is the draftsman could have used an infinite variety of words. But we're concerned with these words. And in any event, we would respectfully suggest that replacement is inherent in the concept of whichever form of words is adopted. If your lordships have the member's case on this, it's a MS 94. So in MS 94, we've got paragraphs 15, 16, and 17. 15 kicks off with the notion that that replacement is OTOs. Well, I've attempted to answer that. It's not. At 15, it said, well, the draftsman could have said any other or any similar index. And at 16, it said that instead of that we can engage in the use of the word adopting, and instead of adopting, the draftsman could have said selecting or choosing. Well, indeed, the draftsman could have done that. The draftsman could have said any other similar prices index selected or chosen by the trustees. But we suggest that the concept of as a replacement is inherent in those form of words also, because you're looking to a process of replacing the first limb of the sentence. And then the third point, whilst we're here, is the Chartbrook point. That's paragraph 17, which makes the point, perfectly accepted point, that we're dealing with the meaning of the expression retail prices index. We're not dealing with the meaning of the expression index. We're not dealing with an algebraic formula. The expression is retail prices index. But that doesn't answer the question in this case. All that the use of the expression retail prices index, that particular label, tells you is that the subject matter of the first sentence is indexes, is prices indexes. It doesn't tell you that the default index as published by the Department of Employment has to have been discontinued in order for there to be a replacement within the confines of the rules. I mean, it's, as my Lord said, the replacement may well be something called the Consumer Prices Index. It's still a replacement. You know, if they were to discontinue RPI and say we'll go with CPI or we'll go with CPIH in the future, that would still be a replacement. There would be no embarrassment on chart grounds arising out of the fact that the defined term was Retail Prices Index. So the fact of the matter is that the fact that the expression is, the defined expression is Retail Prices Index does not answer this point. It may answer the point as to whether the subject matter of the first sentence is prices indices, but it doesn't tell you the answer to the question of whether the Retail Prices Index has to have been discontinued and officially replaced in order to fall within the second limb. The other points in favour of our construction are these. First, that it is common ground, as I've said, that the purpose of the provision is to best protect, by the provision, I mean the provision for the prescribed rate in Rule 30.1.3 and the definition of Retail Prices Index carried across from that. The purpose of the provision is to ensure that the members are best protected in all the circumstances against the effects of inflation. An interpretation which restricts the operation of the index to a circumstance where the Department of Employment or other official body, for its own purposes, decides to discontinue RPI and replace it with another index, does not give effect to that which is, as I say, as is common ground, the purpose of the provision. That is common ground summarised by the Chancellor at paragraph 83 of his judgment, which is at MS 138. An interpretation, our interpretation, which enables the adoption of a replacement in circumstances where RPI simply no longer best serves the object of the provision, is a better interpretation in accordance with that purpose. And the final point that I'd like to make in relation to this is that it's quite wrong for the members to suggest that there is some peculiarity about our interpretation arising out of a disturbance of the inherent balance of power under the scheme. You'll recall the point. The point is, it's a point made by them.
The absence of consent by the employer.
Precisely. Yeah. Precisely, my Lord. It's a point which it's really their only substantive point, made in paragraph 30. That it's an objection to our interpretation that it might conceivably lead to a situation where the employer finds itself with greater liabilities, whereas in all other cases it is suggested the employer would have a veto or a consent power in relation to such an eventuality. Now, the members do not list the other cases which they have in mind, but they are listed in Mr. Justice Warren's judgment at paragraph 78, which is at MS 164. And there are only three of them. They are Rule 30.2, discretionary pension increases, which is MS 274. They're Rule 31, which is general augmentation, which is also at MS 274. And Rule 46, which is the amendment power, which is at MS 284 to 285. And there are 284 to 285. And there are three answers to this. The first answer is that it's common ground that the second limb of the first sentence confers a power to adopt an index on the trustees. Now, the members make a virtue of that power being exercisable in a case where there are two or more candidate indices. That's the members' way of answering our case on adoption and our subsidiary case on without prejudicing approval. The members make a virtue of the point that adoption involves a power to select between two or more indices. There's no getting away from the fact, therefore, that even on their case, the trustees might adopt a more expensive index rather than a cheaper one. But the point, in fact, runs in relation to the single replacement as well. Since the members positively aver that the trustees need to adopt a replacement index, the trustees' decision to adopt a replacement is going to throw a liability onto the scheme which wouldn't otherwise exist. But the first point can be made adequately by reference to the two or more indices point. But the second point is this: it's not right. It's simply not right to say that with the exception of the second limb of the first sentence of Rule 53, the only trustee power which might impact employer liabilities involves employer consent. Now, there aren't many examples on either side of the line, but there is an example, and it's Rule 24.1 at MS 267, the rule which provides the trustees with a commutation power, having consulted with the actuary. Now, the trustees, having consulted with the actuary, and they only need to consult, can decide on generous factors for commutation or ungenerous factors for commutation. And if they go for the former, generous factors, that will impact liabilities. But the third point is this: there's a fundamental difference between the provisions which the members rely upon as involving employer consent, which they say is indicative of the balance of power in the scheme, and the second limb of Rule 53, and Rule 24.1, the commutation provision I've just drawn your attention to. There's a fundamental difference between the members' three provisions and Rule 53, as we read it, and Rule 24.1. Because the members' three provisions are all about augmentation. They're all about giving members something more, giving them an additional benefit, whether that is an additional pension increase over RPI, whether it is a general augmentation of benefits, whether it's an exercise of the power of amendment, so as to introduce a more generous benefit structure. That's what their examples are about. What the two examples I've given you are about, be it the first sentence of Rule 53 or Rule 24.1, commutation, are about giving effect. They're about fiduciary powers concerned with the giving effect of a discretionary element of an existing benefit. They don't confer new or additional benefits. They're about what is an existing benefit and giving effect to it. So in relation to pension increases, and this obviously echoes our position on the cross appeal, you will not be surprised to see the symmetry. In relation to pension increases under Rule 53, what you've got is a fiduciary power to choose the appropriate index to confer a particular increase on the 1st of April in any given year. That's not an augmentation or a taking away.
It's a giving effect to. It's a working through. And similarly, Rule 24.1 on commutation. If you adopt generous factors or you adopt ungenerous factors, that is simply what the trustees in their fiduciary discretion consider to be appropriate in the circumstances in order to give expression to the existing benefit. There's nothing in this balance of PowerPoint. So for all those reasons, we do say that ours is the natural construction and the better construction of what is a very, very, very short point of construction. In the first sentence of Rule 53, we say that you should not be deflected by the contents of the Inland Revenue Appendix because it uses different words, it's addressed to a different thing, and in any event, the different words that it uses are subject to an inherent flexibility, recognised in the second sentence of the introduction to Appendix 10, which itself resonates with IR 12. Unless I can assist you any further.
I don't think so, thank you, Mr. Green. Ms. Campbell?
No, my lady.
Thank you. Would you like to make a start? Mr.
Yes, my lady, if I may. My lady, my lords, there is something that I hope I can do in 5 minutes before the short adjournment, which is to say a few words, if I may, about the application of the well-established principles of construction to the rules of occupational pension schemes. You'll have seen that in the first section of our printed case, we deal with that. The reason I want to deal with this at the outset is that Mr. Green put at the forefront of his submissions, and indeed he started with this morning, a consideration of IR 12, the Inland Revenue Practice Notes. And you will also have seen that consideration formed a substantial reason for the Chancellor to dissent and reach a different view from the majority. So Mr. Green starts with IR 12. I start with the language of the document. And I want to make 2 points about why in our submission that is the right approach, with specific reference to the rules of occupational schemes. First point is this. In Wood and Capita, my Lord Hodge referred on a number of occasions to the importance of considering the nature, formality and quality of drafting of the document in question in deciding how much weight one gives to textual analysis on the one hand and contextual matters on the other. And plainly, on any footing, IR 12 falls in the latter category. In our submission, looking at the matter generally, occupational pension scheme rules are pretty much a paradigm example of documents where primacy should be accorded to matters of textual analysis. They are almost invariably formal, detailed, complex documents which will have been drafted by specialist professionals. These days, that's nearly always specialist firms of solicitors. In former times, one quite often encountered schemes drafted by insurance companies that they would then sell as a package to the employer. But either way, they were drafted by specialist professionals. The courts often come across homemade wills, homemade contracts. I don't think I have ever encountered a homemade occupational pension scheme. And consistently with that, we see in this case that the rules this court has to construe were drafted by a firm of city solicitors, Rowan Moore. That appears from page 247. And as Mr. Green rightly observed in his application for permission to appeal, Rowan Moore were then, and indeed are now, although under a different name, a leading specialist pensions practice. Now, the point about that is that this is the sort of document in our submission where choices of language, of grammar, and of syntax are matters which should be assumed, generally, to have been taken deliberately and advisedly. It is not the sort of case where one can gloss over the particular language that has been used. Indeed, you'll have seen it's in the bundle, but I think it was my Lord Sumption in his Keble College lecture who said that if you ignore these points, you're effectively taking autonomy away from the parties because they have made these choices. It's the only thing within their control. So we say language is of particular importance for that reason. There is a related reason why it's important. The deed that brought these rules into effect, 10th of April 1991, is plainly a bilateral deed. The only parties are the employer, Barnardo's, and the trustees. But it plainly is not a conventional bilateral contract. All occupational pension schemes are established primarily to confer legal rights in the form of pension benefits on present and former employees of the sponsoring employer and their dependents, in other words, non-parties. That in our submission is an important point, perhaps a point that has not been recognised as much as it should have been until recently. We have referred in our case to a number of first instance decisions. There was a case called Spooner back in 2000 where Mr. Justice Jonathan Parker referred to it. Lord Justice Lewison referred to it in the Court of Appeal in the present case. And most recently, my Lord Briggs in Safeway and Newton has referred to this as an important element. And the reason why it's important is twofold. One, it has been long recognised, and it's a statement of the obvious, that members of pension schemes are not similar to the objects of a settlor's bounty in a family trust. The background is the employment contract. The members give value for their rights by their service, and if it's a contributory scheme, as this is or was, by their contributions. Also, the rules are the definitive source for the members to consult and ascertain what their rights are. The court will probably be aware of the fact that it's common practice in occupational schemes for the employer to issue booklets to the scheme members, in a sort of plain English guide to the scheme. Any well-drawn pension booklet has a disclaimer at the beginning saying if there is a conflict between this booklet and the formal rules of the scheme, the rules prevail. So that's why I say the rules are the definitive source. So putting those factors together, our submission is that care should be taken not to apply mechanically or mechanistically, if I can put it that way, principles that have been developed in relation to conventional bilateral contracts, if that would result in rules being interpreted in a way that the reasonable member would not understand. Particularly, I would add, where the dispute relates to the calculation of benefits, which are, as I said, the whole point of the provision of the scheme. If I can have 30 more seconds on this, I can move on before that. So that suggests two things. One, the point I've already made, that language, textual analysis is particularly important because that may be the only tool, to use Lord Hodges' expression, that may be available to the average member reading the document. Secondly, and I am here very much picking up the point made by Lord Briggs in Safeway, caution is required in attaching weight to contextual matters, either because they may be matters known only to the actual parties to the document, viz. The employer and the trustees, or because they may be matters that are known more widely. Lord Briggs gave the example of a common practice in the pensions industry, but that those practices or that information is not accessible either at all or in the real world to the average member of the scheme. I am not suggesting that any of these contextual matters are inadmissible if they pass the well-established tests. It's not a question of admissibility, and I would respectfully commend to the court the observations made by Lord Justice Lewison in the Cherry Tree Investments case that we refer to in our footnote 3, where he said it's not a question of admissibility, it's a question of weight. Given the circumstances, what weight would a hypothetical, reasonable person attribute to contextual matters which are not known or readily available to the very persons who are intended to benefit under this deed? And with that, my lady, I can then move on to the grounds of appeal.
And with that, you reach exactly 1 o'clock on the clock on my machine.
My watch is 2 minutes fast.
So we'll adjourn now and look forward to hearing from you further. 2 o'clock.